What's new is that AI and the use of AI is what's being misrepresented, or how capable an AI program is, or proprietary AI product is what there's a misrepresentation about, but the risk itself is not new.
Another threshold consideration is defining what artificial intelligence is in the first place. Insurance policies and contracts depend on how AI is defined, and subtle differences in language can shape differences in coverage. So, insurance is also only one piece of the puzzle, and an essential other piece of the puzzle is shifting risk via contractual indemnity provisions and contractual insurance provisions.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers for today, Madalyn Moore and Alex Pappas. Madalyn focuses her practice on complex insurance litigation and advising policyholders in insurance coverage matters. As a member of the firm's nationwide insurance coverage team, Madalyn represents commercial policyholders in a range of matters involving property and business interruption loss and commercial general liability insurance. Alex counsels clients on all aspects of insurance coverage. He guides them in obtaining appropriate coverage and resolving disputes over coverage, including in litigation and arbitration. Before joining Hunton Andrews Kurth LLP, Alex served as a law clerk for the Honorable Charles P. Caracas of the U.S. District Court for the Northern District of Illinois. He was also an attorney in the New York office of a major international law firm where he focused on insurance and complex commercial matters in courts and tribunals across the country. The webinar presentation that you're about to watch will be approximately 1 hour, and Madalyn and Alex will be taking questions from the audience once they're finished with their presentation, but you can submit your questions at any time by clicking the Q&A button in your control panel and sending them in there. Now, without further ado, here are Madalyn and Alex to discuss AI on trial, insurance coverage, and emerging risks.
Thank you, Nina, and hi, everyone. We appreciate the opportunity to speak with you today about the exciting topic of artificial intelligence and insurance. It's something Maddie and I and the broader Hunton team have written and thought about extensively, and are excited to cover these topics with you today. We plan to broadly cover 8 different topics. So the first is we'll kick off by discussing artificial intelligence risk and what that means for different organizations, what the sources of those risks are, and how organizations can come to understand and respond to those AI risks. We'll then pivot to discussing defining AI and why that's essential, both in the context of insurance policies, but also in the context of contracts. Because if we don't first know what artificial intelligence is, mitigating risk around it is all the more difficult. We'll then transition to discussing how legacy lines of insurance coverage respond to AI risk. So think of your CGL insurance, your D&O insurance. Many of those policies are an important first line of defense for AI risk. At the same time, AI risks are increasingly being excluded by insurers, and that exclusion is causing new AI-specific insurance policies to come to the market. And we'll discuss and unpack those various different insurance policies. Fifth, we'll focus on AI in underwriting, and we'll discuss how insurers are increasingly asking policyholders about their use of AI in the underwriting process and the significance of this to avoid rescission claims and to make sure that your organization is covered. We'll not only talk about insurance, but we'll also talk about contractual risk transfer. So having indemnity provisions and additional insured provisions and contracts to make sure that you have a multi-layered line of defense for AI risks. And then we'll conclude by talking about what 2026 likely means for artificial intelligence risk and 10 practical takeaways for policyholders and different organizations as they approach AI risk. So with that, I think Maddie will take us through the different types of AI risk and how organizations can learn about their own unique AI risk profile.
Yes, thank you, Alex. So Key to understanding how AI presents a risk for businesses, or the different risks that AI presents for businesses and other organizations, is really about understanding how AI is being used and implemented. Just last year in 2025, over 78% of companies surveyed by McKinsey and Company had reported using AI in at least one business function. And I know many of us are told, hey, in order to make this task more efficient, just use AI. And a lot of us have had, I'm sure, a plethora of meetings and hands-on events and other programming with our employers about using AI in our daily practices and how we can use AI to our benefit. And while AI and the use of AI comes with a lot of promise, that promise is not without risk. And as we're seeing now by the George Washington data on AI litigation database that Alex has up on the screen right now, there are a plethora of lawsuits that have emerged in recent years related to AI usage and risks of AI use, and how AI has maybe gotten it wrong or has created a risk that has led to litigation. Just last month, four new lawsuits were filed related to AI usage and implementation. And this presentation is not to scare you about using AI or talk about why we shouldn't use it. Alex and I both love AI. We play with it a lot, but we also understand that there is an immense risk that comes with AI usage, and a lot of our clients and a lot of policyholders are thinking critically about how their AI usage can impact their insurance coverage, and especially on renewal. When they're renewing their policies and talking with their insurer. And we really want to focus on how we can maximize our coverage for AI risks, because it is a new phenomenon, but the risks themselves that we talk about are not necessarily new. It's the fact that AI is the cause, or is part of the causation, to talk in coverage terms, that is novel here. And that's what's causing a lot of insurers to get very creative. And so we want to make sure that policyholders are also feeling comfortable and confident and being creative when they are approaching their insurer or approaching a risk, that they have coverage and they can maximize the available coverage. Now, the risks that come with using AI that we see a lot, especially in the lawsuits that have been coming out, a lot of AI washing has been happening. So a company executive, director, or officer will say, oh, we have this either proprietary AI product, or we're using this AI product. It's so great. Here's how it's increasing efficiency, but also here's how it's projected to benefit and increase our profits for Q1, 2, 3, or 4. Well, what happens sometimes is profits are not increased, or there ends up being a securities violation or a class action lawsuit on behalf of shareholders related to the executive statements about the company's AI usage. So they'll say, oh, you told us that we were supposed to see this mass increase in profits, but instead it's completely tanked our profits. It's cost us all this money, and this program really isn't as great as we think it is. Or as you said it was in this disclosure statement. And so one common thread that we see is in directors and officers liability insurance cases, shareholder disclosure statements, there being misrepresentations more generally. That's an old risk and has been very common. There are a lot of lawsuits about that, and a lot of D&O blogs and thought leadership on shareholder disclosure lawsuits and misrepresentations in those disclosures. But now what's new is that AI and the use of AI is what's being misrepresented, or how capable an AI program is, or proprietary AI product is what there's a misrepresentation about. But the risk itself is not new. Another common theme that we're also seeing is AI-enabled data breaches. AI has been used to discover new things. For example, AI has discovered peptides for skincare products, first of their kind, not discovered by any scientists. And a lot of skincare brands, I'm sure a lot of us have been seeing, are advertising the use and incorporation of these AI-discovered peptides in their products. Well, by the same token, as AI is being used to discover new things, it's also being used to discover and unearth vulnerabilities within an organization's network. And so hackers and other bad actors are finding loopholes and gaps in companies and other organizations' security systems and their IT programs, and they are able to capitalize on those vulnerabilities and do things like launch a ransomware attack, for example. And so that is also something that is really top of mind for a lot of organizations, is how is AI being deployed to potentially unearth and capitalize on vulnerabilities in a current cyber program that an organization has. Another really common use of AI that we're seeing by a lot of companies is in the hiring and screening process. One of my mentees, I'm a mentor for a lot of college students, and one of my mentees told me about a 2-hour interview he had with an AI bot, and he had to answer a bunch of behavioral questions and talk with the bot. And a lot of companies are using programs like that to screen applicants, but also to screen resumes and cover letters. So if you've ever applied for a job and gotten a rejection 20 minutes after the fact, there was probably AI at play and some sort of screening program or system used to screen your resume or cover letter and then generate a response. And that has happened increasingly in a lot of really large organizations where they have an onslaught of applicants, and it has become more difficult for HR personnel or talent teams or committees within the organization to keep up with reviewing all of the applications and materials that come in. So there is a risk that AI is being used to potentially produce discriminatory outcomes. For example, if you have an organization where it's primarily male, you have primarily younger employees, and you tell an AI program to say, screen these applicants based on our current talent pool, our current employees, and make sure that we are hiring the most diverse slate of candidates. Sometimes, because of the data that AI is fed, that pre-existing younger, more male-leaning demographic within the company, the AI program will assume that the user wants the outcomes from the review pool to match what is currently pre-existing in the company. And so a lot of times the people that will make it to a first round in-person interview with someone who's not an AI bot reflect, the current demographics of the company. And that is very concerning, especially for talent committees that want to make sure that they are keeping up with making their workplaces diverse and making sure that they're hiring different kinds of people among their talent pools and things like that. Another really scary risk is IP infringement. I'm sure many of us have gotten an AI generated meme or some sort of AI generated picture on Facebook. My mom is really obsessed lately with AI generated dog videos. So like a dog cooking a steak or a dog, talking to the press or, something like that. I'm sure we've all seen it. But those kind of things come with the risk of, these AI products are often taking art or taking other intellectual property and creative works from someone else and modifying that work to produce an output. Happens a lot with images, but also with books. I'm sure many of us have seen the large Anthropic settlement that came down earlier this year. Over $1.5 billion it was reached in that settlement. It is unbelievable, but there was a class of authors whose works were being plagiarized by Claude, Anthropic's premier product, and were being used to produce outcomes. And, Claude always has these very quippy literary references, and people could never understand, how Claude spit these things out. Well, it's because all of these books were being scanned and copied and uploaded into Claude's LLM for processing. And that's how it was able to produce the outcomes that it was able to. And so those authors filed a class action lawsuit, reached that over $1 billion settlement. And as AI becomes more prevalent, we are likely going to continue to see IP risk and copyright infringement, trademark infringement, maybe even patent infringement as AI continues to be deployed in organizations. Another big risk that we hear about, hallucinations, incorrect outcomes, things like that. Defective AI products can be really risky if we rely on them for a particular outcome or recommendation, especially those of us that are in the client service industry. We really don't want to produce the incorrect recommendation or produce a recommendation that can create more risks or more headaches or more 10 p.m. phone calls down the line. And so we want to make sure that our AI systems and the products that we're using are not at risk of having mass hallucinations or producing incorrect outcomes. But unfortunately, just like people, AI is not perfect. There are going to be mistakes. We're continuing to see a lot of AI errors and just incorrect outcomes and things that are generated from AI. And so that is likely only going to continue as the technology continues to develop and advance, and as our uses of AI are deployed on more complex topics rather than just saying, what was the date of X, Y, and Z, or tell me a funny joke. Another huge issue that we're seeing is regulatory noncompliance. A lot of states are developing their own regulations. Florida's AI Bill of Rights just passed on Wednesday of this week, for example, and a lot of states are continuing to roll out AI-specific regulation, but they're also continuing to start to develop regulations if they haven't already. We're also seeing the Trump administration taking a more national approach to AI. And so when we're thinking about AI risks and the use of AI, we also want to think about, where is the particular risk located and what kind of regulatory frameworks or issues may be at play depending on the location of the risk or of the deployment. And then another issue we're seeing is AI being used to coordinate or manipulate prices, which create, of course, antitrust violations, and has always been a huge concern amongst antitrust lawyers and other practitioners, price fixing with products or coordinating or anything like that. And so the SEC, the FTC, and the DOJ have become increasingly concerned with price fixing activity and coordination through the use of AI and trying to uncover where AI is used throughout that process. And then finally, we're also concerned about surveillance, privacy violations, and facial recognition. Now, facial recognition is not a new thing, right? Facial recognition has been around for a while. It's one of the premier technologies that was used during the Darfur crisis in 2003, for example. But AI-powered facial recognition is a lot more detailed and analyzes things such as facial expressions, tracking your facial movement, tracking, the pattern of where someone walks. And this can improperly collect personally identifying information without someone's consent, especially when AI is being used to enhance surveillance in public spaces. That's a huge concern in DC for those of us in the area, because DC, there's cameras everywhere. And you can't escape the cameras that are pointing on every major thoroughfare in the city. But what happens when we deploy AI enhanced surveillance throughout the city? Are we able to adequately make sure that people are consenting to that surveillance? That's a huge open question right now. And auditing AI risk. Very important that at the organizational level, that we are looking at AI risk from a kind of forest for the trees kind of view, and we are seeing both overall how AI is being used across an organization, but also very locally how AI is being used. And when we're talking about auditing AI risk, we mean that you are reviewing your current insurance program, but you're also reviewing your vendor contracts and making sure that if AI use is at play, you are covered for any risk that could result from the deployment of AI, and hopefully not, but in the event a claim results from the use of AI and AI hallucinates or produces a wrong outcome, that you can shift the risk to your insurer, or more beneficially, or more importantly, as Alex will get to those vendors who may have used AI to help you produce a particular outcome or to help enhance their services. And so when we have an AI audit and we're able to review our AI program broadly, we're giving everyone within the organization a better understanding of where the particular vulnerabilities are and where AI risks are the most prevalent in an organization. So for example, an organization that doesn't use AI in its hiring or screening process really isn't that concerned about AI risk and, hiring discrimination or employment discrimination or any sort of employment liability, but they may be more concerned if they're using it to help deploy software or to automate communications with clients, what kind of risk of misrepresentation or hallucination can result. And so having a more detailed understanding of where the risks lie helps for more effective action when risks eventually do come to the surface. And, like I mentioned, there is the revealing of where AI gaps may exist in insurance products or in vendor contracts when we're looking at all of our insurance products and all of our contracts. Now, key considerations when this audit is taking place, as I alluded to earlier, looking at business function risk, what functions are AI being used to help enhance, whether it's screening tools, automated marketing campaigns, product recommendations, customer service chatbots. Understanding those things helps to form a more adequate and a more responsive audit of an organization's AI risks. But also we want to look at industry-specific risks. One common issue in the healthcare field, for example, is if AI is used to analyze a particular patient's medical history, will AI produce a diagnosis or a recommendation for treatment that is either incorrect or is not compatible or puts the patient's health more at risk? Those things are not going to be thought of for a construction company, for example. There's no patients, there's no diagnoses. And so, thinking about more strategically what industry level risks, what professional liability concerns are at play can also help you tailor your both AI specific insurance provisions, but also your contractual risk transfer provisions and make them the most effective for your particular industry and your particular business functions. And then we also are looking at location. As I mentioned earlier, there are a lot of states rolling out particular AI regulations and a lot of states that are beginning to do so. And we also have concurrently in the background, we have Trump's AI action plan at the federal level. And so when we're drafting contracts, especially those risk transfer provisions, we want to focus on where the location of the risk or the deployment is, because we might have to deal with regulatory compliance with one or more of these patchwork regulations and complying with one or more of, for example, the Florida AI Bill of Rights and or the Texas AI Usage Act. And so we want to make sure that our risk transfer provisions, our policy provisions take into account those particular regulations so that we don't end up in a situation where we don't have coverage because of a regulatory violation.
Thank you, Maddie. So I think the main takeaways are that AI risk is sort of everywhere, and an important first step is understanding how a given organization uses AI to then address and create risk transfer strategies based on how a given organization uses AI. Another threshold consideration is defining what artificial intelligence is in the first place. And this is significant in two places. One is in insurance policies, and the second is in vendor contracts. If we don't know what AI is, it's impossible to have an insurance policy that fully covers that scope of insurable risk. And the same is true if you're shifting risk via indemnity provisions, if it's unclear what artificial intelligence even means in the first place. There's no single universal definition of what artificial intelligence is. As a domain, it covers many different areas. It covers machine learning. Here, think about Spotify making recommendations based on learning from user data. There's natural language processing, so understanding human language. Think of Siri or Alexa. We have computer vision, which analyzes images or facial recognition, as Maddie was talking about. And then we have generative AI, which everyone uses now, ChatGPT, cloud, things of the sort. The definitions can be really broad, they could be very narrow, or they can be something in between. But it's essential to think about that definition on the front end to make sure that the risks you intend to transfer are those risks that are intended to be or are supposed to be transferred. Um, you could think of the Terminator or artificial general intelligence or artificial superintelligence. As these technologies become more advanced, the risk of getting the definition wrong becomes all the more paramount because it might encompass something that causes a whopping amount of liability, and that's not something that an insurer intended to cover, or it's not something that you intended to shift via an indemnity provision. Um, as I mentioned, insurance policies and contracts depend on how AI is defined, and subtle differences in language can shape differences in coverage. Later on in this presentation, we'll go through different affirmative AI specific insurance coverages and different AI exclusions. And what's notable across both the exclusions and the affirmative coverages is that the definition changes. So, for example, if it only applies to generative artificial intelligence, that would change whether something is or is not insured, and that can have very significant, impacts for your organization. Um, Another thing that's coming up in the definitions of AI is circularity. So a lot of definitions will actually define AI to be AI. So if you see this one here, it says generative artificial intelligence means content created through the use of any artificial intelligence application, tool, engine, or platform. And so it's effectively defining generative AI to mean AI, which just begs the question of what artificial intelligence is in the first place. And these types of dilemmas will become all the more salient as coverage disputes emerge about whether AI insurance coverage is triggered in the first instance or whether AI exclusions apply and will actually block coverage. So the devil's in the details with the definition. And before approaching AI risk transfer, it's paramount to think about what actually you're trying to insure and what risks you're actually trying to shift. And I think Maddie will now tell us about all of the legacy insurance programs and how those respond to AI risk.
Yes, thanks, Alex. So, as I alluded to earlier, the risks that AI poses are not new. And with that, a lot of our traditional insurance coverage forms, whether it be commercial general liability, IP insurance, D&O insurance, or EPL insurance, employment practices liability, cyber insurance, should respond to AI risks. And one key thing to think about is the result from using AI. What is resulting? Is it bodily injury? Is it property damage? Is it a particular D&O claim? Are we having a ransomware attack? Because once you think about the result and the risk that is presented, you realize that traditional insurance policies are meant to cover these risks. One very common, unfortunately, example that we're seeing is bodily injury resulting from the use of AI, and commercial general liability insurance ordinarily covers the risk resulting from bodily injury or property damage. And theoretically, right, if AI causes bodily injury, like it did in this case, Rain versus OpenAI, commercial general liability insurance should be able to respond to the risk and offer coverage. And in cases like Rain and others that have been filed against character technologies, there has been an epidemic of young people using AI and unfortunately receiving assistance with crafting things such as suicide notes or death letters or suicide ideation assistance. And although AI is the alleged cause of the resulting bodily harm, the underlying risk is still bodily injury for these cases, and traditional commercial general liability insurance should still respond to these kind of risks. Same thing with D&O, directors and officers liability coverage. As I alluded to earlier, there have been instances where certain directors and officers of a company will misrepresent an organization's AI capacity, or they will misrepresent the capacity and the efficiency and efficacy of a proprietary or in-house made AI product. And ordinarily, things such as misrepresentations and shareholder disclosure statements are commonly covered with D&O coverage, and D&O insurance policies often will step in whenever there is a shareholder disclosure lawsuit or a derivative litigation resulting from misrepresentations and shareholder disclosures and other statements made to shareholders. And so, again, even though AI is at play and the misrepresentation is about either AI usage, results, or development, the risk is the same, that there was a misrepresentation or there's some negative result from something that a director or officer of a company said or did. And as mentioned, D&O insurance should be able to respond to this kind of risk, irrespective of AI being involved. And then there's Mobley. Like I alluded to earlier, many companies are starting to use AI in their screening and hiring processes. And Mobley was a particularly interesting case because the plaintiff, Mobley, alleged that Workday's AI-powered hiring program was producing discriminatory results, specifically discriminating against people who were African American, had a disability, and over the age of 40. Now, Mobley had applied to Workday over 10 times at this point before the lawsuit was filed, and he produced an application, he filled everything out, submitted supplementary materials, the cover letter, the resume, and he was rejected in like 10 minutes the last couple of times he had applied. And so he was immediately suspicious that a human had not reviewed his application, especially since he applied at, I believe, 1 or 2 in the morning. He just said, there's no way that someone is up at 1 or 2 a.m. reviewing my cover letter. This has to be AI. And part of the issue in that case is also that the AI program was asking questions that were indicative of a lie detector test, or that were kind of similar to what you would receive in a lie detector test. And a lot of employers in California specifically are regulated by the use of lie detector tests in employment applications and to screen applicants. A lot of states, including California, Washington, and some others, do ban the use of lie detector test results or taking a lie detector test more generally in the application process. And so a key allegation there is also that, that employment practice and that particular law is being violated by the use of the AI program because it is asking questions and trying to elicit answers that represent or are very similar to effectively a lie detector test. And then, of course, again, as I alluded to pretty much the entire presentation earlier, but the use of AI in kind of exploiting cyber vulnerabilities. T-Mobile's data breach in 2022 was probably the most clear example we've seen of this. And so a bad hat actor had exploited an AI-enhanced application programming interface, or an API, to unlock sensitive customer data. There was a key vulnerability there, and the use of AI allowed the cybercriminal to not only discover the vulnerability, but also to discover that sensitive personally identifying information, PII, of T-Mobile's customers was at risk. And so that is hugely important, especially when we are signing up for, things like Wi-Fi, broadband, cell phone contracts, things like that. Or if you ever buy an Apple product, there is a huge privacy disclosure. And part of that disclosure often says, we will not use your personally identifying information for any improper purpose. We will keep it safe. We will make sure that, it is not subject to improper use. And instances like these put T-Mobile and other organizations who use similar privacy disclosures at risk for claims from consumers or other clients that their data is improperly being used and is not being kept safe. And then IP insurance. Tanzer is another case that resembles the Bartz versus Anthropic case that I mentioned earlier, where there was that big settlement in the billions of dollars. So Tanzer was another creative works case, and one of the key allegations were from not only authors of written works, but also news organizations. A lot of broadcasters and other content owners filed a bunch of lawsuits against OpenAI, Microsoft, Anthropic, Meta, among others, about the manipulation of their creative works by the AI programs. So much so that, it's not only that the AI program did not have permission to use their creative works, but that also their works were distorted in such a way that completely changed their character and completely went beyond, for example, a parody or any other common permissive use or fair use of copyrighted material. And that became very concerning, especially for broadcasters who are trying to deliver reliable news, accurate news, and things like that. When things are AI generated, it can be really difficult to discover how AI manipulated particular content, but also what is and what is not original content becomes extremely difficult, especially as AI becomes more advanced.
So legacy insurance products, like all of the ones Maddie just went through, provide an essential first line of defense for organizations thinking about AI risk. And organizations shouldn't assume that just because AI itself is novel, that the risks it generates are somehow novel too, because they're not. And the legacy insurance programs are likely to be an essential first line of defense and the first place organizations should look. Um, that landscape, though, is changing. So, across the past year, insurers started introducing AI specific exclusions. So, Hamilton Select, for example, had one for generative artificial intelligence. Lloyd's has one for general AI systems or actions. And then Berkeley Insurance, there's one that's an absolute AI exclusion that goes through chapter and verse and effectively, vitiates insurance coverage for any form of anything related to AI in any which way possible. And what's significant is that these exclusions are somewhat of a sliding scale from, maybe they just exclude generative AI to all the way to we exclude anything that's in any way related to artificial intelligence. And this is significant because it changes the baseline presumption that legacy insurance programs will respond. And it makes it essential for policyholders going through the insurance renewal process to make sure that their insurance policies don't have AI exclusions if their organization is using AI. And this is something where it might make sense to negotiate to have the exclusion taken out or to have the exclusion limited in some way. Throughout 2026, it's likely that AI exclusions will become increasingly ubiquitous and increasingly common. Here's the one from Berkeley Insurance Company that I had just mentioned. And as I said, it was absolute. And as you see here, it goes through basically every potential use of AI and says why it's excluded. And these forms are not things that have been tested in court yet. So for insurance coverage litigators and insurance practitioners, these will become increasingly significant areas of litigation. As you see here, there's a definition of artificial intelligence too. So there will likely be debates about whether this exclusion does or does not apply to a specific technology. And that's something that'll be litigated in 2026 and beyond. Similarly, here's language from a Lloyd's AI exclusion, and it goes on and is pretty broadly defined. And as you'll see here, the definition of artificial intelligence is different, meaning the devil will be in the details about whether or not a specific insurance policy exclusion does or does not apply. at the same time as these exclusions have been rolled out, insurers have been increasingly rolling out affirmative AI-specific coverages. One of the first to do this in around 2018 was Munich Re, and that product was relatively limited. It was a performance guarantee for certain technologies that use AI. So think about a factory that promises 99% performance to their customers. And let's say the factory on a given day only performs at 97%. This insurance product would insure that 2% delta. And that one's been around for some time. The biggest development has likely been the Chaucer and Armilla product. This one is meant to eliminate any ambiguity about whether artificial intelligence is covered. And this is meant to cover third-party liabilities for AI system failures. Recently, Chaucer and Armilla announced that their limits for this program are increasing. And this is sort of one of the products at the forefront of standalone AI-specific insurance. There's two other ways that AI-specific insurance is coming about. The first is as an endorsement to existing policies. So, for example, there's an AXA XL endorsement adding AI-specific insurance coverage to certain cyber policies. And this is interesting because, as we had talked about before, the cyber policy in theory should already cover the AI risk, which raises the question of why the endorsement is significant in the first place if it's already covered under the legacy form. And I think the idea here is that there's perceived uncertainty about whether or not legacy insurance products will respond, which is creating demand for more specific, clearly delineated insurance coverage. The other domain in which this is existing is specific companies that offer products that are AI related. So Google is a great example, have partnered with insurers to offer insurance specific to that product. And that exists in the context of existing Google Cloud customers. These products are likely to continue growing and expanding throughout 2026. A lot of it currently is driven by startups, many based in London, Armilla based in Canada. And these startups are likely to continue to grow and introduce new products in tandem with existing legacy insurers. Considering the landscape of legacy coverage and new affirmative AI coverage, there's a few takeaways for organizations thinking about AI-related risk. The first is to conduct regular coverage reviews to understand whether or not your legacy insurance products will respond to your specific AI exposures. And this is where what Maddie said about auditing AI risk is so essential. You can't do an effective coverage review if you don't know how AI is first being used across your organization. So an essential first step is understanding how you use AI, what risks that generates, and then devising an insurance program that responds to it. As I had already mentioned, organizations should be on the lookout for AI exclusions. They should scrutinize policy language with brokers or coverage counsel to make sure that there's no uninsured exposures. And they should be sure to look for complementary coverage. Sometimes D&O and cyber, for example, go hand in hand. And it's important to make sure that AI risks aren't slipping through the cracks between an otherwise comprehensive insurance program. And this is where working with brokers or coverage counsel to make sure that there's a comprehensive AI-ready insurance program. As AI risks, increasingly grow, this becomes all the more important. Another domain where this is happening is AI and underwriting. Insurers are increasingly asking policyholders to provide information about how they're using AI, which is a topic Maddie will cover.
Yes, thank you, Alex. So, like Alex mentioned, insurers are becoming increasingly interested in the underwriting process about an organization's use of AI and the deployment of AI. And so conducting those coverage reviews and those audits is so important, not only because you have a sense of organizationally where the risks are, but also so that this information can be relayed to the insurer and in the underwriting process, because a lot of insurers are not only asking how is AI deployed, but they're also looking at how much revenue is being generated from AI solutions and the use of AI, which can be important for things like business interruption coverage, contingent business interruption coverage, and other kinds of coverage, premiums, and all sorts of other calculations that go into the cost of insurance, but also how much coverage you are able to receive and negotiate with the insurer, whether it be during the initial purchase or the renewal of particular policies. And another huge question that a lot of insurers have been asking is how much is AI being used to generate original content, and whether organizations are generating original content in the first place. As we can see, this is a Philadelphia coverage application for an insurance policy. And one of the key questions is whether the applicant produces original content as part of their business, whether it's part of advertising, content creation, logo and brand development. Insurers are very interested in making sure that there aren't particular risks, or if there are, they're identified in the application process of, for example, is there a risk that AI was used and someone else's creative work was used in generating a company logo, or in generating a marketing material or ad or other material that the company's branding is on, and how much coverage should be allotted to that risk, and how should we be drafting provisions to account for that risk, or on the converse side, potentially exclusions for that particular risk, because that insurer may not have the capacity to offer coverage for those particular risks that a business faces, depending on how they use and deploy AI. And, one of the kind of issues that keeps reoccurring here and keeps resurfacing is the definitional ambiguity around AI. There's no universal definition. And so we want to make sure that during the underwriting process, we are using precise, very business-specific, organization-specific definitions of AI, and that we're negotiating those things with insurers. Because while the risk is scary and it's new and there's a lot of unknowns around AI and insurance, and this is still relatively new for the insurance industry, there's an immense opportunity here to really partner with insurers in drafting policy language that is specific and narrowly tailored to maximizing your organization's coverage for AI risks. Think of it like a narrowly tailored suit. You could have a suit that perfectly fits your organization and make sure that you are able to experiment with and deploy AI across your organization, because you have language that is, one, clear for the industry, clear to the insurer, and you and the insurer understand and have a mutual understanding of what needs to be covered when it relates to AI. Another thing that is really important is making sure that vendors and the usage of AI by vendors is verified. Sometimes in a lot of different policies, the use by a vendor or the misuse by a vendor may not be covered. And we want to make sure, especially for contingent business interruption coverage, that AI usage is addressed. And we require disclosures from vendors to make sure that if we have a contingent business interruption risk that arises out of the use of AI, we are able to verify which vendors precisely are using AI and possibly shift the risk to those vendors through contractual provisions or insurance provisions in those contracts with our vendors, so that our insurer isn't getting cold feet because our vendors are using AI and we might not have the adequate contingent business interruption coverage should a vendor's use of AI cause a disruption in the operations of a particular business. And of course, we want to make sure that throughout the underwriting process, this is a great time to engage coverage counsel, to engage your broker, and to make sure that you are able to workshop ideas for not only defining AI, but thinking about, making sure that coverage applications are accurate and that they are thorough, because we all as coverage counsel have seen cases where there's a misrepresentation in an application, or an organization's statements about a particular thing are not entirely accurate, and that is prime grounds for a coverage denial. So we want to make sure that our applications are accurate and that we're being as thorough as possible.
So insurance is also only one piece of the puzzle, and an essential other piece of the puzzle is shifting risk via contractual indemnity provisions and contractual insurance provisions. And this is all the more essential now when a lot of the AI specific insurance products are sort of in their infancy and there's uncertainty about the scope of coverage. Those forms haven't been tested in court. It makes it all the more important to create bespoke contractual risk transfer when working with vendors and other third parties. And this can make sure that all of your AI risks are addressed. This can clarify responsibility for losses that stem from AI failures, and it could make sure that AI partners are held accountable. But I think most significantly is that these types of provisions allow you to tailor risk management in a way that sort of off the shelf insurance products might not necessarily do. And this gives you the opportunity to have a very broad scope of coverage for all types of AI risks that can materialize. There's a couple sort of tips and tools for the trade. One is what is artificial intelligence? We've already been through this, but this is an essential threshold question that folks should not forget. Scope is also essential. So, what AI technologies are included, what uses are included, what users are included. Another consideration is transparency. So making sure that the organization or vendor you partner with actually tells you about how they're using AI, because you don't want to find out that there's some AI related exposure that you just didn't know was happening. So you contract with a third party. You might not know that that vendor is using AI in a way that is imperiling your business. And that makes it all the more essential to transfer that risk upfront when contracts are being negotiated. Uh, Another way is not just indemnity provisions, but also additional insured provisions. So we've talked a lot today about uh, insurance that a specific organization could buy, but you also can, make insurance claims under your vendors or your partners' insurance programs as well. And this is where thoughtful insurance requirements come in, making sure that those third parties also have insurance that you can make a claim under. So then you have sort of a three-layer level of defense. You have, your insurance, their insurance, and then you have indemnity, all working together to make sure that there are no uninsured exposures. There's a lot of tips and tricks for drafting these provisions. One is just specifying the types and levels of coverage that you require. Do you want primary insurance, excess insurance? Do you want an umbrella? What type of limits are important given the exposures that your organization faces? And this is, again, where the AI risk audit comes in. Answering a question like this or drafting an insurance provision like this requires an upfront understanding of the risk in the first place to make sure that you can procure adequate insurance from your vendors. The second is making sure your business is an additional insured on a vendor's insurance policy so that there's no dispute about whether or not you can actually make a claim under that policy. Third is requiring the maintenance of insurance, not just the initial procurement of insurance. So oftentimes, a lot of these provisions will say X vendor needs to go buy insurance, but they won't say that X vendor needs to maintain that insurance. So at the end of a policy period, the insurance will just lapse or expire, and you're basically out of luck in that scenario. That makes seeking maintenance all the more important. And fourth, this one I always find funny, but there's lots of disputes about whether or not you actually can get access to the policy to determine whether or not you're covered in the first place. And sometimes vendors or insurance companies just won't give you the policy when you're an additional insured. And one solution to this is to write into the contract that the other party has to provide the policy upon request. Oftentimes, a lot of these provisions are about certificates of insurance, but they're not necessarily about the policy itself. And the certificate of insurance isn't all that helpful if you're trying to fight a coverage declination, in which case you actually need the full policy in order to respond. So I think the takeaway here is when you're thinking about transferring AI risk, you have your insurance policies, you have someone else's insurance policies, and then worst comes to worst, you have shifting risk via indemnification provisions to make sure that you have a comprehensive suite of protections for the wide array of AI risks Maddie mentioned earlier. These risks will change in 2026 as AI growth and adoption becomes way more ubiquitous, and that makes thinking about these things early and often all the more essential.
Yes, as Alex mentioned, 2026 is bound to be a really exciting year. I know we're almost at the end of Q1, but we are expecting to have a lot more activity in the coming quarters through more AI lawsuits. Like I said last month, 4 new AI lawsuits have been filed in federal courts across the country related to AI errors, AI system failures. There's also greater risk of bias as AI implementation continues through things like the hiring and screening process for a lot of companies. We also expect to see coverage disputes arise under traditional insurance programs, our CGL, our D&O, EPL, and so on. We do expect to start seeing, not just the new AI lawsuits, but also lawsuits between insurers for the plaintiffs or defendants in those lawsuits and those particular plaintiffs and defendants about whether their particular insurance will cover defense costs for those lawsuits related to AI risk or AI failure. We also are hoping to see some disputes and some tests in court of the new forms. We are not encouraging lawsuits, but Alex and I are very interested in seeing how courts will treat the new novel insurance products and the new forms. And so it will be exciting to see how courts interpret and treat these forms in relation to not only traditional forms, but also in conjunction with an organization's pre-existing insurance program. We also expect to see insurers continuously refining how they define AI and how creative they continue to get in their development of exclusions. We see a lot of exclusions in 2025 that were new and beginning to roll out. We expect that to continue amongst all insurers pretty much. So we're keeping an eye out for how exclusions continue to evolve, but also how the definitions of AI continue to evolve as defined and crafted by insurers. Another big thing that we're expecting to see more activity in this year is looking at the state patchwork, state-by-state patchwork of AI regulations. Like I mentioned earlier, the AI Bill of Rights has now been passed in Florida. There is the California AI Training Data and Transparency Act, and there's a lot of questions surrounding the rollout of that, but also how compliance is going to be ensured. The Texas AI law was effective in January of this year. The Colorado AI Act, the same. The Colorado Act was kind of, the first of its kind, and I think is what inspired a lot of states to start with their own proprietary AI regulations. So we're expected to see a lot more activity at the state level, but also more activity at the federal level because of the executive order that came down in December from the Trump administration, the Ensuring a National Policy Framework for Artificial Intelligence. That executive order tries to establish a federal, a uniform AI policy framework. So we are concerned with how a federal AI framework is going to be implemented and how it is going to be received among the states, especially when states are actively in their legislative sessions tweaking and revising and drafting and redrafting their particular AI regulations. Does all of that stop because of the development of a federal framework? How much is the federal framework going to take from states? And then also, as we're given the directive through this executive order and this program to allow federal agencies to challenge AI state laws, how does this impact the effect of regulations that policies may or may not be drafted to require compliance with, or that vendor contracts might include a mention of or require compliance with? And how are states going to receive this, and how are they going to adopt and comply with a possible uniform framework when they have their own frameworks that they've developed? How is that going to be received? Or is that going to be challenged in court by the state's attorneys general? We don't know. Those are still open questions that, we're very closely watching on our end, and we're hoping to have some more insight into as the year goes on.
So I recognize we're at time, so I'm going to leave you with, you should audit your AI risk. You should think about it. You should consider transferring it to your existing insurance programs and make sure that those existing insurance programs respond. You want to make sure that AI risks aren't excluded from those programs. And you should consider other folks' insurance and indemnity provisions to shift risk, and also consider new and novel AI insurance products, which 2026 will see a lot of excitement on that front. I recognize we're out of time, but if anyone has a question or two, Maddie and I are happy to answer it.
Wonderful. Well, thank you both so much for that thorough presentation. We really appreciate both of your time and sharing all of that information with us. As they mentioned, there is time for questions. So if you haven't had a chance to drop in your question, you can always do so by clicking into the Q&A box and sending them in there. It looks like we have about one question right now. We'll see if any other ones come through, but thank you for giving us the extra time. This first one is, what do you feel are the most significant legal and operational risks associated with deploying AI?
So I think the unfortunate answer, and it's a lawyer answer, is it depends. As Maddie went through earlier, if you're a healthcare organization, the answer is very different than if you're a consumer products organization or if you're in retail. So I think it depends on the type of industry you're in. It depends on the locations in which you operate. AI risks in New York might be different than AI risks in Illinois because of differences in the statutes that apply. So I think no two organizations are the same, and I think that highlights why an AI risk audit is essential, but it also highlights why a thorough coverage review based on that risk audit is all the more paramount, precisely because no two AI risk profiles are the same, but also no two insurance programs are the same either.
Thank you, Alex, for that insight. This next question is, why do you think clearly defining quote unquote AI and what that is in insurance policies is critical for contractual certainty?
Yeah, so I think it depends on the specific technology you're using. So a lot of people use technology, but they might not know whether or not that technology qualifies as AI or not. Think about Outlook nowadays. You log on to your email, it might have an AI component to it, but does that necessarily mean that everything originating from Outlook is or is not AI? And this is true for every technology. You could, pigeonhole it into AI or not. And whether or not that technology fits in the bucket or doesn't dictates whether or not it's insurable and dictates whether or not it's excluded, and also whether or not the risk can be transferred. So certainty about, is your technology indeed AI and something that's covered by the insurance policy is a threshold question that sort of precedes all the other considerations about whether or not it's insurable.
Awesome. Thank you for that insight, Alex. And then I'll just ask the last question of, I know obviously this is a vastly changing landscape. So are there any resources that you two use or that you would recommend for our audience members today to kind of stay up on these trends as things shift and change? What would you recommend for that?
Maddie, you take this one.
So I subscribe to the Armilla AI newsletter. Armilla is one of the kind of startup companies that is manufacturing their own AI-specific insurance product. And so they have a ton of resources in their weekly newsletter that discuss, emerging risk, things that they are seeing and hearing from prospective clients or their clients are bringing to them. And, they also have a pulse on what's going on in the insurance industry. And so I think that's a really great resource. And you get a weekly newsletter, like I said, that's kind of lays everything out for you, which I really like. I also like to keep track of the GW AI litigation tracker just to see, what sort of allegations are coming up, what are we seeing, how could these particular lawsuits potentially develop into coverage disputes, which is something that we're thinking of all the time. How is coverage litigation going to change with AI at play? So those are two resources that I use the most, and just, local news sources, national news sources, things like that, NPR, all of the above. But really the Armilla and the GW Tracker I think are the two most consistent that I use.
And I have two to add to that quickly. One is a shameless plug for the Huntin blog. Our team is publishing on AI and insurance issues all the time. Every month, I'd say we have several posts about sort of the new and latest developments. And then brokers, so Willis Towers Watson, Locked In, they're also putting out a lot of awesome content discussing the intersection of AI and insurance. That content's coming out all the time.
Awesome. Well, thank you both so much for sharing those resources. Thank you both again for your time and answering our audience questions. And thank you to all of our audience members who asked questions. We always really appreciate your participation. We want to thank you all so much for joining us for another Justia webinar. I wanted to remind you all, as I did at the top of our presentation, of the services available to you through our website platform, Justia Elevate. It's our innovative, feature-packed website solution that's designed especially for law firms. It's built on a powerful WordPress platform and offers tools like the Justia AI Writer to help you craft content, Justia Chat to help you reach new leads, and Justia FAQs for AI to help you stand out in AI results. With all these tools and more, you'll have everything that you need to stand out online, and plans start at just $82.50 a month when paid annually. So you can check your pricing at elevate.justia.com/price. Thank you all so much for joining, and thank you again, Alex and Madalyn, for your time. Have a wonderful rest of your day, everyone.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.